Excellencies, distinguished guests, dear colleagues, dear students, because I know there are students in the room, ladies and gentlemen, it's an honor and a pleasure to be here with you today and to address this distinguished audience. As has been said, I've been invited to talk about the value of democracy within the EU legal order, and the timing for discussing this topic could not be more adequate. It seems to me that democracies fall either because foreign enemies succeed in destroying them, or because they become hollow from within. As for the external threats to democracy, we do not need to look far back in history or far outside the EU to see this. The Ukrainian people, who are fighting for freedom, democracy, and justice against Russian aggression, offer a stark reminder. The war in Ukraine can also be seen as a struggle between a young democracy and an authoritarian regime, much like the stand of the Greek city-states at Thermopylae against the imperial power of Persia, where free societies resisted domination by an empire. As for internal threats, we may look at the fall of the Weimar Republic and the coup d'etat carried out by armed forces in Europe and Latin America. The collapse of the Weimar Republic exemplifies what is now called democratic backsliding, a process in which a political party or movement attains power through democratic means only to erode the very institutions that sustain democracy. Democratic backsliding is not a relic of the past, confined to history books. It is a phenomenon we are witnessing today. In their best-selling book, How Democracies Die, which I strongly recommend you to read, especially for the students in the room, two Harvard professors, Levitsky and Ziblatt, describe with striking clarity how democratic systems can be dismantled by those entrusted to defend them. Unlike coup d'etat that extinguish democracy overnight, these two professors correctly observe that democratic backsliding unfolds gradually, like a flower slowly deprived of sunlight and water. As the title of my lecture suggests, the question that arises is how we Europeans can keep democracies strong, vibrant, and healthy so that they can endure evolving threats brought about by democratic backsliding. To put it simply, how does the EU protect and promote the value of democracy? In order to answer that question, one must first understand the concept of democracy as it is embedded in the EU legal order, and then ask how to protect and to promote it. I will illustrate my suggested answers by looking, you wouldn't expect otherwise, at the case law of the Court of Justice of the European Union. So first, what is democracy in the EU? Citizens must understand how democracy works within the EU legal order so that they can recognize emerging threats and defend themselves against these threats. To begin with, the European Union is founded on the values enshrined in Article 2 of the Treaty on the European Union. Respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights define the very identity of the European Union as a common legal order. And that term was coined in the full court judgments of the 16th of February 2022, the so-called conditionality regulation judgment. Those values stem from the constitutional traditions common to the member states and seek to create, I quote, a society in which pluralism, non-discrimination, tolerance, justice, solidarity and equality between women and men prevail. End of quote. This is Article 2 of the Treaty on the European Union. Like the EU flag, which features a circle of 12 stars on a blue background that symbolizes unity, harmony, and interdependence between the peoples of Europe, those 12 values operate as the moral compass that helps Europeans navigate through uncharted waters. They underpin a certain ideal of what the member states and their citizens must strive to become. We Europeans firmly believe that every human being deserves to be treated with equal dignity, whether woman or man, old or young, poor or rich, sick or healthy, foe or friend. This ideal of equal dignity underpins the value of democracy. In the EU, democracy is inclusive. Democracy cannot be equated with the tyranny of the majority. Respect for the value of democracy means that minorities cannot be discriminated against, and that the courts must be strong in protecting the rights of the political minority, even if that protection leads to a negative public opinion. The EU therefore guarantees a democratic space of liberty, where we can love whom we want, pray to the God of our choosing or not pray at all, and live a life without worrying about the color of our skin. Next to being inclusive, in the EU, democracy is composite in nature. On the one hand, representative democracy underpins the institutional functioning and design of the EU by vesting the European Council, the Council, and the European Parliament with democratic legitimacy. The European Council and the Council are legitimized through national governments which are, and I quote the treaty, themselves democratically accountable either to their national parliaments or to their citizens. That is to include both parliamentary regimes and presidential regimes in the equation. Whilst the members of the European Parliament are directly elected by EU citizens in free and fair elections every 5 years. On the other hand, national democracies play an essential role in European integration. That is why the European Union is composed of states which have freely and voluntarily committed themselves to the common values referred to in Article 2 TEU, and that is a quote from the famous Republika judgment of 2021. It is in keeping with the value of democracy that a candidate state for membership may join the EU. Similarly, it is in light of that same value that a member state may democratically decide to withdraw from the EU, as the Brexit example shows. In democratic terms, this means that the European Union and national democracies are not in competition with one another, but complement each other, reinforcing democracy overall. In my view, the value of respect for democracy seeks to protect a democracy, a term coined by my Brussels academic colleague, Philippe van Parijs, and that expression was further filled in by a Greek scholar teaching in Oxford, Kalypso Nikolaidis, who has defined the concept as a union of peoples understood both as states and citizens who govern together but not as one. This duality renders the value of democracy composite in nature, making EU and national democracies interdependent. The healthier national democracies are, the more democratic the European Union is, and the more democratic the European institutions become. In turn, the more democratic impetus the EU institutions are provided with, the more EU law improves national democracies. Just like two symbiotic organisms, there is a common interest in protecting the value of democracy as a whole, since that interdependence favors a mutually reinforcing relationship between EU and national democracies, creating these democratic synergies. And third, in the EU, democracy is not only inclusive and composite in nature, democracy is also woven into what it means to be a citizen of the European Union. The status of EU citizenship, which is, I quote a court, intended to be the fundamental status of nationals of the member states, gives access to the democratic life of the EU. That is the title of Title II of the Treaty on the European Union, democratic life of the EU. As an EU citizen, I have the right to vote and to stand as a candidate in European and local elections. In a recent judgment, Commission versus Malta, decided in April of this year, 2025, the court held that by setting up an investor citizenship scheme, which amounted to the commercialization of the granting of Maltese nationality, following a transactional procedure, Malta had failed to fulfill its obligations under the treaty provisions on EU citizenship and the duty of loyal cooperation. In so doing, the Court of Justice sent a clear message to the member states. The member states cannot commercialize the grant of nationality, as this is repugnant to the values on which the EU is founded. EU citizenship is not a commodity. From the perspective of democracy, the Court of Justice is telling that the commercialization of EU citizenship would amount to buying one's way into the EU democratic process, which is fundamentally at odds with the very essence of democracy. EU citizenship should be construed in a way that promotes and protects the integrity of the EU's democratic constituency. In order to have a democracy, you need to have a demos first. As the famous song goes, money can't buy me love, nor should it buy something as profound and principled as EU citizenship. Inclusivity, a mutually reinforcing relationship between EU and national democracies, as well as EU citizenship, help us understand the value of democracy within the EU legal order. However, the picture would be incomplete without examining the relationship between democracy and two other values, namely the rule of law and fundamental rights. This is because one cannot exist without the two other. Together, these values deliver a full, cohesive package. They are interdependent, given that fundamental rights are little more than empty promises where there is no democracy and no rule of law. That it is impossible for a democracy to work properly without respect for the rule of law and fundamental rights, and that the rule of law is devoid of substance without democracy and fundamental rights. That's why we always speak about the triangle: democracy, rule of law, fundamental rights. Democracy thrives only when both EU institutions and member states respect the rules of the game. The political process at EU level works properly only if every actor plays by the same rules, whether they win or lose. Those rules imply that neither the EU institutions nor the member states are above the law, and that it is for an independent judiciary to interpret those rules. Independent and strong courts are important for democracy, as they guarantee that disputes are not solved by violence or intimidation, but by a judge ready to rule without fear or favor. The observance of those rules amounts to upholding the rule of law within the EU. Democracy must operate in keeping with the system of checks and balances established by the treaties. That system is not an end in itself, but a means of protecting individual liberty by preserving the vertical and horizontal allocations of powers laid down in the treaties. As James Madison wrote in the Federalist Papers number 51, and that is a text of 1790, so it's 235 years ago, the principle of separation of powers and that of conferral, Madison spoke about attribution, aim to ensure a double security to protect individual liberty. The EU legal order embraces that approach. Horizontally, the EU institutions must act within the scope of their powers without upsetting the principle of institutional balance. That's the checks and balances principle, the functional separation of powers principle. Vertically, the balance of power between the EU and the member states, as provided for by the treaties, must be safeguarded. That's the principle of conferral. And when it comes to the exercise of powers, the principles of subsidiarity and proportionality. Democracy within the EU legal order requires unwavering respect for fundamental rights. In essence, the rule of the majority must never intrude upon the sphere of self-determination and personal autonomy that belongs to every individual. Certain decisions lie beyond the reach of the political process, safeguarding the very dignity of the human person. The right to private and family life constitutes a paradigmatic example in relation to which the court has held that restriction on the exercise of that right must be limited to what is strictly necessary. And in the working visit this morning with the representatives of the Supreme Constitutional Court and the Supreme Court of Cyprus, we discussed that in more detail. So now that I have sketched out what democracy means, how it is understood in the EU, inclusive, composite, and linked to citizenship of the Union and exercise of the political rights of the citizen, the question now, in a second movement, arises how to protect and promote democracy in the EU. How should we, Europeans, defend democracy? Well, first of all, guaranteeing free and fair elections is essential for the proper functioning of democracy. But obstacles to the democratic process must be removed. Indeed, free and fair elections is the basis. Obstacles to that process must be removed. We'll see in a second movement that it is not enough. For example, in the 2015 Grand Chamber judgment Del Vigne, the court held that a member state may exclude persons from the electoral roll in elections to the European Parliament only if such exclusion pursues a legitimate aim and complies with the principle of proportionality. Indeed, disenfranchising a person should be subject to strict limits. Remember that democracy is inclusive and that everyone in principle must be able to participate. In the United States, there is a big debate about disenfranchisement disenfranchising minorities in the framework of the registration of voters. So that is why the Court of Justice of the European Union's case law is very strict on disenfranchising people. In this case, the condition of proportionality was met because the French legislation excluded from the right to vote in the European Parliament elections only persons, like the applicant, who had been convicted to a very serious crime. In that case, it was a case of murder. Similarly, in Junqueras vs., the court held that a person elected to the European Parliament acquires the status of member of that institution at the time of the official declaration of the results, and enjoys from that time onwards the immunities attached to that status. The obstacle, which was the obstacle in that case, was the fact that the elected member to the European Parliament had to swear an oath on the Spanish Constitution before taking the seat in the European Parliament. The court said, no, that is not required or cannot be required as a matter of European Union law. The election should suffice to be elected. And more recently, in the important cases Commission against Poland and Commission against Czech Republic, the court held that denying EU citizens residing in a member state of which they are not nationals the right to become a member of a political party infringes EU law. In so doing, the Court of Justice stressed the importance of political parties in the democratic life of the EU. It held, and I quote, "Political parties, one of whose functions is to field candidates in elections, fulfill an essential function in the system of representative democracy on which the functioning of the European Union is founded." So since nationals of other member states can participate in the electoral process for the European Parliament and for local elections in whatever member state where they reside, they must also be able to take part in the life of political parties whenever these elections are at stake. However, as I said, while free and fair elections are essential to upholding the value of democracy, they alone are not sufficient. Democracy must be safeguarded beyond the ballot box by building trust in the democratic process, by engaging citizens, and by ensuring long-term stability and justice. Let's look in these items in turn. So first, building trust in democracy. And that is a huge issue in present-day conditions, as you know, in many of our member states. For democracy to flourish, both at national and at EU levels, citizens must be closely involved in the EU decision-making process. By staying well-informed about the decisions adopted by the EU legislature and administration, they can actively engage in public debate and express agreement or disagreement with the decisions taken. Transparency, openness, and accountability go hand in hand, fostering citizens' trust in their representatives. This openness conveys an idea of democracy where politicians are not above reproach, but subject to criticism so that bad policy decisions can be modified and reviewed. Both the Court of Justice and the General Court held in Access Info Europe and in De Capitani the principles of publicity and transparency are inherent into the EU legislative process. In both of these cases, it was the works of the Council which were at stake, namely the Council not giving access at the time to the identity of the member states which in the legislative process had made proposals for change. The Court of Justice, in line with the General Court's first instance judgment, said no. the identity of the member states must be revealed. De Capitani, a similar holding by the General Court for the workings of the so-called trilogue, that is the conciliation attempts between the Commission, the Council and the Parliament to get a single text approved. And so there also, the identity of who proposed what, both at Parliament level and at Council level, is absolutely essential. Because the right of access to EU documents gives concrete expression to the principle of transparency. It enables EU citizens to exercise their democratic rights and creates these democratic synergies of which I spoke at EU and national level. By having access to the documents held by the Council, the electorate of a member state may monitor the position taken by that member state's government within the Council as an EU institution. And the Council is one of the two chambers of the EU legislature. The same holds true in relation to national parliaments, which are able to check whether the executive has complied with the negotiation position laid down for that executive. The right of access to EU documents, as interpreted by the EU courts, makes it very difficult for a national government to avoid taking responsibility for unpopular legislative acts adopted at EU level, if it is apparent from the internal documents of the Council that that government never resisted the adoption of those acts. In the same way, it cannot take credit for an EU legislative act where internal documents prove that that government consistently opposed the adoption of the act. So therefore, transparency enables citizens to understand and to monitor the democratic process. However, here also, transparency is not enough, given that citizens must also be able to require public officials to assume responsibility for their actions. Whilst the glass-house government is essential for democracy, should a public official fracture its integrity, he or she must be held accountable and bear the consequences. Citizens may hold publicly elected officials accountable either by voting them out of office, by launching a parliamentary investigation, or if need be, by bringing civil or criminal proceedings against them. Accountability is not only grounded in the value of respect for democracy, but also in the value of respect for the rule of law, given that those who exercise public power cannot be above the law. Citizens' trust in the democratic institutions would be called into question if European taxpayers' money was used to fund the interests of corrupt politicians. Put simply, impunity is accountability's worst enemy. From a democratic point of view, this was precisely the context in which the Court of Justice delivered its seminal ruling in Eurobox promotion in 2022, Grand Chamber judgment, with the reporting judge, our Vice President. In those joint cases, the Court of Justice held that a series of rulings of the Romanian Constitutional Court had to be set aside, since the application of those rulings had the effect of causing, I quote, a systemic risk of offences concerning VAT fraud and corruption, which were committed by high-level officials, including cabinet-level ministers, going unpunished. That systemic risk of impunity was at odds with Article 325 of the Treaty on the Functioning of the European Union, which requires the member states to ensure that, I quote, cases of serious fraud and corruption affecting the financial interests of the Union are punishable by criminal penalties that are effective and that act as a deterrent. Seen in this slide, Article 325 TFEU, which has direct effect, is a powerful tool which gives concrete expression to the values of democracy and respect for the rule of law. Moreover, freedom of the press and media pluralism are vital for a democracy. A free press acts as the public watchdog, enabling citizens to monitor those in power, thereby building trust. And I'm quoting here from an opinion of Advocate General Ruiz Garabo Colomer in the Damgaard judgment. It's a very beautiful opinion. Freedom of the press and media pluralism give concrete expression to the values of freedom and democracy, since those rights are essential to building public opinion in a society that allows divergent views and tolerates disagreements, echoing a society in which pluralism and tolerance prevail, as provided in Article 2 TEU. Because of democratic considerations, restrictions on the freedom of the press and media pluralism are subject to strict scrutiny from the courts. As the Court of Justice has consistently held, the purpose of the press in a democratic society governed by the rule of law justifies the press in informing the public without restrictions other than those that are strictly necessary. In Real Madrid, a Grand Chamber judgment, equally on the report of our Vice President, the Court of Justice was asked to interpret the Brussels I regulation in the context of the recognition and enforcement of a Spanish judgment in France. That judgment provided that the French newspaper Le Monde and one of its journalists had to pay damages to a professional football club, Real Madrid, on the ground that they had published an article suggesting that Real Madrid players were doping, which was found to be untrue. The Spanish court ordered Le Monde and the journalists to pay, by way of compensation for non-material damage suffered, 300,000 euros for the newspaper and 30,000 euros to Real Madrid and to a member of its medical team, respectively. The French Cour de Cassation asked the Court of Justice whether it could rely on the public policy exception, or ordre public exception, set out in the Brussels I regulation in order to deny the recognition and enforcement of the Spanish judgment at issue, since it was liable to impose an unjustified restriction on the freedom of the press. The Court of Justice held that the recognition and enforcement of the Spanish judgment in France should not give rise to a chilling effect that would deter the press from informing the public about matters of public interest or involving political speech. Whilst press articles that undermine the reputation or rights of others may not go unpunished, no sanction must produce such a chilling effect. Real Madrid is an important contribution to the respect of the value of democracy in the EU legal order, since in a cross-border context, no European newspaper and no journalist must fear destitution because of an obligation to pay compensation exceeding the material and or non-material damage actually suffered by the persons concerned by the article at issue. Moreover, and this brings me to what a famous philosopher Karl Popper called the tolerance paradox, according to which unlimited tolerance must lead to the disappearance of tolerance. As already mentioned, Article 2 TEU states that the values on which the EU is founded seek to create, I quote, a society in which tolerance prevails. But does that provision mean that the EU must tolerate intolerance? Does the EU have to, for example, tolerate views which are rooted in hatred and call for the annihilation of other human beings? In this regard, Popper said, and I fully agree with him, that, I quote, if we extend unlimited tolerance even to those who are intolerant, if we are not prepared to defend a tolerant society against the onslaught of the intolerant, then the tolerant will be destroyed, and the tolerance with them. Of course, needless to say, the challenge in applying that paradox is to know where tolerance ends and intolerance begins. Read in the light of that paradox, I find that the judgment of the General Court in RT France against Council, a Grand Chamber judgment of the General Court, is well-founded. In that case, the General Court dismissed an action for annulment brought by a media outlet that was wholly funded by the Russian state against a council regulation that temporarily prohibited that media outlet from broadcasting content on the ground that it had engaged in a propaganda campaign targeting civil society in the EU, justifying and supporting Russia's military aggression against Ukraine. The General Court reasoned inter alia that the Council had limited RT France's freedom of expression in a way that was in keeping with the Charter, since the challenged regulation pursued two legitimate aims, namely the protection of the Union's public order and security, and the application of pressure on the Russian authorities in order to bring an end to the war, whilst also complying with the principle of proportionality. RT France versus Council shows that in the European legal space, the democratic process must be based on shared norms of mutual respect and a recent debate which revolves around the concept of human dignity. By excluding intolerant voices from the public debate, the EU shows that it is ready to defend the values on which it is founded. Let's now look, in a second move, to the way of engaging citizens. I told we should first increase the trust in the democratic process as such. How can we engage the citizens? In the EU legal order, democracy is not limited, as I have already said, to electing public officials. It must also incorporate members of civil society into the decision-making. By incorporating such members, EU legislation becomes more transparent and pluralistic. Engaging citizens in the democratic process is essential, for there is no greater threat to democracy than the apathy, that's a Greek word, right? Apathy of those unwilling to stand up for what is right. In her famous book entitled The Origins of Totalitarianism, Hannah Arendt explained the dangers of citizens feeling alienated. Citizens who are detached from the democratic institutions and caught in alternative realities of social media may easily be led astray by the haunting melody of populist siren songs, which seek to dismantle the system of checks and balances put in place by liberal democracies and to replace it by authoritarian leadership. That is why civil society organizations must be protected by law. They help nurture a sense of belonging to a community of shared values and prevent individuals from feeling left behind. That is why EU law also protects the freedom of association, enshrined in Article 12 of the Charter of Fundamental Rights of the European Union. In a 2020 Grand Chamber judgment, Commission versus Hungary, the Court of Justice ruled, for example, that the Hungarian transparency law, which imposed obligations of registration, declaration, and publication of certain categories of civil society organizations, directly or indirectly receiving support from abroad, and abroad includes other member states of the European Union, exceeding a certain threshold, was contrary to Article 12 of the Charter. This was because that law imposed an unjustified restriction on the capacity of associations to receive financial support sent from other member states or third countries. From a democratic perspective, two direct implications flow from this judgment, Commission versus Hungary, Transparency of Associations. First, this case sheds light on a new kind of protectionism, one that seeks to prevent the free movement of ideas and civic participation. This type of protectionism is very dangerous for democracy. By preventing funding from abroad, the activities of civil society organizations, notably those that are critical of the government of the home member state, may be severely reduced. Through lack of funding, dissenting voices fall silent, which in turn undermines the quality of democratic debate in the home member state. Second, it is true that increasing the transparency of the financing of associations is a legitimate objective under EU law. However, that objective may not be relied upon in order to establish a general presumption according to which funding that comes from abroad is contrary to the interests of the home member state. Promoting a general mistrust against civil society organizations that receive funding from other member states is at odds with the principle of mutual trust. Public life and public debate in the home member state must be open to influence and be influenced by natural or legal persons established abroad. Put simply, in the EU legal order, civil societies cannot be victims of civic isolationism, since, as Hannah Arendt observed, this prepares the soil for democratic backsliding. And the last element is this long-term stability and justice concern inherent in democracy. Despite what some may claim, the democratic process should not be seen as an enemy of science and expertise. In modern societies where information is crucial, democracy must integrate the perspectives of experts and scientists to ensure that public policies are sound, informed, and rational, serving the common good. The COVID-19 pandemic has shown how easily societies can fall into the trap of epistemic trespassing, when individuals, after a quick internet search or exposure to social media posts, believe themselves capable of solving complex scientific problems. Or even worse, start believing in conspiracy theories. Democracy must therefore be anchored in the pursuit of the truth. The pursuit of truth enabling citizens to exercise their political rights with full awareness of their choices. Experts and scientists should not be portrayed as adversaries of democracy, but rather as essential contributors who foster long-term stability and advance progress through study, debate, and research. Needless to say, those expert views may also serve the common good, in spite of contrary opinion by some. If these expert views are really provided independently and in a way insulated from partisan political pressure. In Commission versus Germany, decided in 2010, the court held that Germany had failed to fulfill its obligation under EU law by incorrectly transposing the requirement that the authorities responsible for monitoring the processing of personal data by non-public bodies perform their duties, I quote, with complete independence, as was required in the then applicable directive. Germany posited that the notion with complete independence did not preclude the Länder, that is the federated states in Germany, supervision, which in turn allowed the government of the respective Bundesland or an administrative body subject to that government to influence directly or indirectly the decisions of the supervisory authorities, or as the case may be, to cancel and replace those decisions. Such supervision was in keeping with Germany's understanding of democracy, as the administration must be subject to the instructions of the government, which is accountable to the parliament. So you see the whole chain of legitimation in a parliamentary system. However, the Court of Justice of the European Union took a different view, holding that protecting those regulatory authorities from influence was an objective pursued by the EU legislature, so as to insulate these authorities from any political pressure when determining whether the processing of personal data complied with EU law. As to the arguments relating to Germany's understanding of democracy, the court dismissed them by holding that independent agencies and democracy go hand in hand. In the key passage of the judgment, the court held, I quote, "The principle of democracy does not preclude the existence of public authorities outside the classic hierarchical administration and more or less independent of the government. The existence and conditions of operation of such authorities are in the member states regulated by the law, or even in certain states by the constitution, and those authorities are required to comply with the law, subject to the review of the competent courts. Such independent administrative authorities often have regulatory functions or carry out tasks which must be free from political influence, while still being required to comply with the law, subject to the review of the competent courts. That is precisely the case, the court said, with regard to the tasks of the supervisory authorities relating to the protection of data." End of quote. So it's a long quote. That line of case law regarding the independence of national regulatory authorities has further been developed in the last 15 years, and most notably in a line of case law, which I will not explain any further, in which our colleague, esteemed colleague and President of Chamber Konstantinos Lykourgos acted as reporting judge. In my text you find all the footnotes. This brings me to my concluding remarks for this lecture. Democracy in the EU legal order is inclusive, composite in nature, and woven into what it means to be a citizen of the European Union. Democracy defines the identity of the EU as a common legal order, which strives to protect and promote values that revolve around human dignity. Democracy is not tantamount to the tyranny of the majority, but is about protecting minorities. Democracy respects fundamental rights by ensuring that each and every one of us enjoys a sphere of self-determination that allows us to live a life as we see fit. Democracy is nothing but an empty promise without the rule of law, understood as the system of checks and balances that protects individuals from the arbitrary exercise of power. As John Adams famously said, democracy is a government of laws, not man. Moreover, within the EU, the system of checks and balances has a transnational dimension that can assist national democracies experiencing democratic backsliding in returning to the path of freedom and justice. EU law is by its very nature the law of democracy, as it contributes to building trust in the democratic process, protects civil engagement, and long-term stability based on the rule of law. As the case law of the Court of Justice shows, the value of democracy pervades the entire body of EU law. It means that EU law may be relied upon to stop authoritarian tendencies. But most importantly, democracy is a moral choice and a personal commitment. As the famous American philosopher John Dewey once wrote, "It is a way of life controlled by a working faith in the possibilities of human nature." At the end of the day, it is for each and every one of us to fight for a strong and vibrant democracy. Civil indifference and apathy are the worst enemies of democracy. Paraphrasing the famous words of Benjamin Franklin, the EU is a democratic union of democracies, if we, Europeans, can keep it. Ευχαριστώ.